So good evening, everybody. This is the first of what we think might be a number of presentations organized ultimately by a group called the Bar Association of Metropolitan St. Louis. But we'll just call it the Bar Association. And there are a number of members here who are Bar Association members, and more particularly are part of a task force created by the Bar Association to help out healthcare workers on the front lines of COVID. Tonight, we're imagining two basic co-presenters, myself and Adrienne Davis. She's there with the headphones on, and she'll have a chance to introduce herself more thoroughly in a moment. So first things first, on behalf of BAMSL, our deep thanks to all of you who are doing this. This is a unique cultural and medical crisis, and we are all very much in your debt. So thanks to all of you, and we're proud and happy to be a part of whatever help that we can give. My name is Rixie. You can see it there on the screen. It was my mother's maiden name. My parents gave it to me as my name. Last name is Ruffin. And I'm a lawyer here in St. Louis with a firm called Sandberg Phoenix. I've been an estate planner for 9 years now, and am part of the BAMSL structure as well. So that's what brings me here. And I'll let Adrienne say a few words about herself.
Sure, thanks, Rixie. I'm Adrienne Davis. I'm not the same Adrienne Davis who's at WashU Law School, who's a very esteemed international scholar, but I'm the other Adrienne Davis. I'm an estate planning attorney, and so I have been doing this work with wills, trusts, powers of attorney, et cetera, for clients for 20 years here in St. Louis. I started off at a big firm downtown, transitioned to a bank for a little while, and am back in private practice in a small firm in Clayton. I'm part of the BAMSL Probate and Trust Committee that Rixie chairs, and our mission is, generally to help lawyers who practice estate planning, but in light of this particular crisis, and we learned of a need in the medical community to get more information out about the various estate planning documents and what to do, I volunteered to help Rixie with that. And there's a number of other members of the committee on the call today. They may, if this is a really helpful call for you, we may do future ones and record it, et cetera. And so we wanted to have other people who would be ready to do a similar service.
Exactly so. So here's how we're imagining this going. We're roughly blocked off an hour. That may be limited by the Zoom rules. I don't know. Adrienne is our Zoom host, and I'll defer to her on tech questions.
No, I sprung for the more than 40 minutes of Zoom, so we're good to go.
Okay, so we'll plan for an hour in the sense that that's how these meetings get scheduled, but Q&A sessions can go as long as they go, but we'll try to be respectful of people's time. And our prepared remarks will be well under an hour, but we'll happy to stick around as long as there are questions. We're imagining this to be broken down into two big chunks. The first chunk is based on our understanding that a number of residents' primary concern is a certain document called variously a medical directive, an advance directive, a healthcare power of attorney. It goes by a number of names and has a number of components. And there's some folks who say, that's my main concern. And in fact, I understand there's a publicly available document. And wow, if I could even just use that, all I really need is some guidance through that document. And to provide that guidance is the first part or first half of tonight. And that's going to be really Adrienne's segment. That's her wheelhouse. The second half, and Adrienne will be a big part of this too, is a very brief introduction to estate planning and the concept of just wills. Because we also hear that certain residents say, like lots of folks do, hey, I don't have a will. I really should get a will. In fact, now that I think about it, I don't even know what a will does and why I need one, but I hear that I should have one. So we want to help you understand what wills do and what they are and what basic estate planning is. And then maybe for those of you who want to go that extra step and get a will, hopefully we can put you in touch with some local volunteer lawyers who have expressed a willingness to turn something around pretty quickly. And hopefully we think even pro bono, which means for free. So that's the second half of tonight. And for some of you, that will be a big part of it. And for others of you, that might not be so relevant, but that remains to be seen. Okay, the first part is that medical directive part that I mentioned. Adrienne is not only our subject matter expert on that, but she's been our tech guru. She's the host of this meeting, and she has created a Google Drive, and I think even a WashU specific box. And hopefully most of you will know what that term means. And at this point, I will turn it over to Adrienne to sort of guide us through the technology and the substantive law on these documents.
Thanks, Rixie. Yes, so Dr. Wise set up a box, which I think is a method that you all are familiar with. And in that box, I went ahead and loaded 2 separate folders. One of the folders has Missouri-specific forms, and the other one has Illinois-specific forms. And these forms are related to the document that is an advance directive, which is also called a healthcare declaration or living will, and then a medical power of attorney. For both Missouri and Illinois, those forms are publicly available. You don't have to go to a lawyer to get those forms. There's a state interest in people being able to fill those out if they want to fill them out. The Missouri Bar form is put on by the Missouri Bar, and the Illinois form, the best one that I found, is on the website for the Illinois Department of Public Health. The reason you would use Missouri versus Illinois has to do with where you live. If you're a resident of the state of Missouri, you use the Missouri form. Likewise, if you're a resident of Illinois, you could use the Illinois form. So I'm going to start with the Missouri form just on the assumption that everybody, most people are Missouri residents, but we wanted to have the other one covered. I have that document in the box, and if we didn't get everybody access, we'll get you access to that. It's also on the Missouri Bar website, so we can get that link out to you too in an email. So I'm looking at the document. The document comes in a variety of forms. It comes in a straight static PDF that you can print off and handwrite. Yes.
Sorry to interrupt, but there's on the chat thread here, there's a message about getting an error message in the box. And I don't want you to make assumptions that people can see things if they can't.
Okay.
We may need to add everyone via, add their emails. We sent out a link to it, but I wonder if Mark and I may need to go through and add everyone's emails to it. Or what we may need to do is go in there and create a share to send it out. But we can do that, or if you can send that link now, then people may be able to, because I hate to not have people have access to the document that you're going to go over unless you have a way of sharing it on your screen, maybe.
I think I do. So let me pull that up. Let's see. Just bear with me for 1 second while I put this up. I actually just added these links to my notes.
So while Adrienne is doing that, I'll just add one thing, which is that this is the first of these presentations that we've done. This is not something that we go around from group to group and do this and have some stock speech prepared technologically or substantively. You all are guinea pigs, hopefully in the good sense of that word, but tonight is literally the first time that we've done this. So for better or for worse, you're sort of seeing the sausage being made here as we go along. So bear with us. We're excited to be here, happy to be a part of it, but this may not be as polished as it would be if this were, attempt number whatever down the road.
Yes, and I have the links, and so I'm posting them in the chat now. For this conference. Okay, so I've added a couple of links there. The first link that I added is the link to the kind of overarching page on the Missouri Bar site that lists some information about the various forms. You can get it in static form that you can print off and fill out and then have the witnesses sign. And then there's also a fillable form on there, and that's the second link that I clicked. Let's see, and I will share my screen. Here we go. Okay, can you all see, Rixie, can you see the medical power now?
No, I have all pages up, and it would be tiny even if I could see it.
Okay, then never mind. I'm going to stop sharing my screen and I'll just talk. Okay, so hopefully you all, if you're at a computer or if not, you can copy that link and I'm sure we can find another way to get you the link too. So this is the Missouri Durable Power of Attorney for Healthcare form and Healthcare Directive. In some states, those are two different forms. You are permitted to combine it into one form. So the first part of that form is a medical power of attorney for healthcare. That's where you're allowed to appoint an agent who can make medical decisions for you if you can't make them for yourself. You can designate one person and then a couple of successors after them in case the person you designate can't act. When you are filling it out, the information that you're going to need to have is who you want to name. Generally, what we recommend is name someone who would be good at communicating your preferences to doctors. They don't have to be a doctor, but they just have to be able to process information and communicate the decision that you would want them to make. You're going to need their name, address, and phone number preferably. If you don't have all that information, that's not going to affect the validity of the document, but you want to have the name. The address helps identify the person, and I think the phone number is a great idea because then it makes it easier for the person reading the document to get in touch with your agent if necessary. So on the first page of it, it's really simple. You just fill in your name, your address, anywhere where it says I blank, that's another place where you fill in your own name. And then you designate what county you live in, designate your agent. You know, I guess I would ask too, Rixie, if you notice anything in the chat where somebody asks a question as we go, will you interrupt me or flag me down?
Sure will. And on that point, if somebody has to hop off this call before it's done, whenever done is, and if you think that you would like to go forward with some estate planning options, well, it won't have helped you if we haven't given you the contact email.
Good point.
The idea was we were going to give it at the end, but of course, nobody here is obligated to stay throughout the entire time. So without further ado, here is the dedicated email address for if when this is all over, you think, yeah, I need a will, I need a financial power of attorney, and I want to talk to a lawyer and start a real attorney-client relationship. Well, how do I do that? Here's how you do it. We're not going to try to hide the ball. You ready? Healthcare pro bono at BAMSL.org. So healthcare pro bono, which is PROBONO, at BAMSL, Bar Association Metropolitan St. Louis .org, O-R-G, right, not com. So healthcare pro bono at BAMSL.org. If you got to get off the call, that's the email address that we were going to give out, so we'll give it out now. And just sort of, we'll be checking it. Let us know that you want to proceed. You can save everybody's couple of steps, and you can say then that you're an Illinois resident or a Missouri resident, whether you're married or you're single. That should be enough to get the ball rolling. Okay, but just wanted to get that out there. Adrian, back to you.
Great, thanks. And I added that email to the chat too, so you can grab it from there. Okay, so walking through the form a little bit more, there will be clauses like reference that the power of attorney is durable. Durable just means it's a power of attorney that works if you're incapacitated too. Regular powers of attorney technically lapse if you become incapacitated, which would be pretty worthless for a medical power of attorney. So basically all medical powers of attorney are durable. There is a box on this standard form where you select whether or not you want one physician or two physicians to certify that you're incapacitated. And that would be the point in Missouri at which the doctors would start listening to your agent instead of you. I mean, you know, I feel kind of silly saying this to doctors, but obviously you talk to the patient if the patient can talk back to you. So just because you designate somebody in here doesn't mean they get to overrule you. The next, you know, this is a really important box at the bottom of page 1 of the document. And this is where one of the powers you give your agent is the power to prohibit or withdraw healthcare, even if your death might result as a result of that removal of care. And then there's 2 boxes to check. you pick one or the other and you initial it. The first box authorizes agents to direct a healthcare provider to withdraw artificially supplied nutrition or hydration. And then the second box does not authorize them to do that. So that's a place where you can express that reference, that wish. You will initial, if you see a blank that says initials, you just go ahead and write your initials in that blank. The next thing that might be a little confusing on page 2 is under number 6, there's a set of boxes that you can initial to determine a couple of things. One is determine what happens to my body after my death. Legally, that's known as the right of sepulcher, and that's literally who gets to decide where the body goes, the funeral home, et cetera, to make the arrangements. You want to initial that box if you're wanting your agent to have that power. I think most people generally do. The next would be you would initial if you want your agent to authorize an autopsy or postmortem examination. And then the last is there's a box that says delegate healthcare decision-making power to another person, delegee, as selected by my agent. And the delegee shall be identified in writing by my agent. What that means is you appoint an agent. If you initial this box, your agent also has the power to name another delegee to exercise these healthcare powers for you. So for instance, I could name my mom as my healthcare agent, and if I wanted my mom to have the power to delegate some of those powers to my dad or my brother, if I initial that box, my mom would have that power to delegate. The next box is an authorization of anatomical gifts, that's organ donation, and the form allows you to either check all of the above or list specific reasons why your body can be donated for research. And then you can also, you can kind of specify whether you want it to be all organs donated or some restrictions on that. You can also initial to prohibit all anatomical gifts. Sometimes I think people worry if they have a particular health condition that their organs are not eligible for donation. But what I typically tell people is, well, it doesn't hurt. If you're inclined to donate them, go ahead and authorize it. And then if the medical institutions want to turn them down, they can turn them down. Okay, so that's it for the healthcare durable power of attorney. That's really the process of naming someone to make medical decisions for you. Then the second part of the document is called the healthcare directive. That's also known as a living will, advanced care directive. It's the part where you express your wishes with regard to life support if you're in a persistent vegetative state and your physician does not believe that you're going to recover. The first thing that you don't have to fill out both parts of these forms. You can just do part 1 and name agents, or you can even just do part 2 and do the healthcare directive, or you can do both together. On this form on page 2, the directive part, there's a number of things that you would initial, and you need to initial it if you want those things to be withdrawn, if you meet the conditions of being in a persistent vegetative state unlikely to recover. So the things listed there are artificial nutrition, hydration, surgery, antibiotics, ventilator, radiation. You can designate other procedures, et cetera. So you'll want to go ahead and initial those blanks if you are giving permission for all of those things to be removed. There is a blank in the form. I think this, I'm not a blank, but a paragraph that says, if your physician believes that one of these life-saving measures will result in your recovery, then you're not saying, like say for instance, let's use ventilators. So if you had initialed ventilator and someone was looking at this and saying, hey, wait, they said no ventilator. Well, if your physician believes that the ventilator is going to make a difference and that you could recover, then it's fine for them to go ahead and still do that. That would be distinguished from a case where somebody maybe who was in a car accident and, very seriously injured and the ventilator was literally keeping them alive. And then skipping ahead, so then let's talk about how a Missouri healthcare declaration and durable power of attorney for medical care is is executed, signed. So, you know, for most legal documents that we sign these days, if you're buying a house, et cetera, we're allowed to do DocuSign where you sign with your finger on your phone, or you could sign through video conference or whatever. But unfortunately, estate planning documents are kind of the last bastion of having a piece of paper and being in front of the other people when you sign it. So the witnessing requirements and the notary requirements are important, and we recognize that that is difficult right now under current circumstances. We are actually lobbying the governor and the legislature to allow witnessing and notary by video conferencing, but to date, I don't know that that's an initiative that has moved forward. So at this point, you should assume that to sign one of these documents, for it to be valid, you do need to be in what's called the conscious presence, which means in the room, you know, kind of within earshot. I think you could easily still be 6 feet apart with the witnesses to your document. And so you would need 2 witnesses. They need to be over 18 years old. They need to have legal capacity, which just means that they're not incompetent. And preferably they're not named as the agents in your document if possible. We are kind of parsing every letter of the law right now to just figure out if we can make that work. But in an ideal situation, it wouldn't be the people you name as agents. And then you definitely need those 2 witnesses if you're signing the directive part of this form. That's the part where you say remove life support if I'm in a persistent vegetative state. If you are not signing that part, then instead what you need is a notary public, okay? The notary with the stamp, you know, I got a stamp, who needs to be in the room with you when you sign it. That we recognize that is a little more difficult. That is the part that gets you the power of attorney part of the medical document. So if you're going to sign both parts of the documents, you just round up those 2 witnesses and the notary with you all in the same room, preferably not sharing pens. And you know, I mean, you guys know your procedures. And then you would sign, they would each sign, the notary would sign and stamp it, and then you would be good. At that point, once the document is executed, I would make a scan copy of it, and I would put it in your medical chart, and I would give a copy to your healthcare agent. And if you have an attorney, I would give it to your attorney. So that's it on the Missouri form. Maybe I'll move on briefly, real short, on the Illinois form, because the Illinois form is very similar. Illinois' form is based on a statutory form. So they actually put the text to their living will and their power of attorney for healthcare in their statutes. And so the Department of Public Health has good forms for both of those. On the Illinois form, you only need 1 witness, and you actually don't need a notary. And I had forgotten that requirement, but that I double checked it in the statute tonight. So if you're an Illinois resident, you have an easier time of executing this document. You need to be an Illinois resident. Yes, ma'am.
Really quick, sorry. There's a question in the chat that is anyone allowing people in the waiting room on this Zoom? And I think you're the only one with
sorry. Hold on. Yeah, it's
sorry to interrupt.
Yep. No. Thank you for interrupting.
Yeah, sorry about that. I got some people told me they were trying to get in, but they were stuck in a waiting room. So
sorry. I had the waiting room up. Sorry, people who were in the waiting room. I had the waiting room up, and then it went behind my screen another window. We did record this session, and we are recording this session, so we'll make the whole thing available, and we will do later sessions as well. So we finished talking about the Missouri Healthcare Directive and Power of Attorney. Now we're talking about the Illinois Power of Attorney for Healthcare and Living Will Declaration. The form in substance is very similar. You appoint an agent, you can appoint some backups. On the Illinois form, the backup agents are at the very end, so you get through the whole thing to get to the end. Illinois has similar boxes that you check where you, there's a box where you check the quality of life is important to you, and that's the box that really says if you are not going to wake up from a persistent vegetative state, you want life support to be removed. And then the second box is written in plain English. It says staying alive is important to me no matter how sick I am, how much suffering, cost of procedures, etc. So this will be to a medical audience, very common sense for filling that part out. You sign it and date it in the presence of a witness, and then you have the witness sign and date it too. The Illinois form that we provided is 2 separate forms. And so the second one is a living will declaration. That is the one that needs 2 witnesses. Okay, so that's where I got it. So the living will declaration in all states, I guess, typically needs 2 witnesses. Let's see. Let me go back to my outline. And so that was really the main substance. We could either kind of take questions now on those documents, or we could, it's 8 o'clock now, we could move on to our brief overview of like the other estate planning documents, wills, and what you do if you just don't have a will or these documents at all. Rixie, do you want to chime in on anything there?
Yeah, let's go ahead and just take questions now while the forms are fresh in people's minds. And not that we couldn't later and won't later, but if there's anything pressing on somebody's minds, for those of you who are recent arrivals, you missed part of that discussion about the Missouri forms for healthcare powers of attorney and advanced directives, but we're happy to answer any questions about it as best as we could. But any specific questions now before we move forward?
I'm seeing some questions in the chat, so I'll go ahead and address some of these first. One question: do these documents require that you only that you reside in one of these states, Missouri or Illinois, or do you need to be a legal resident for them to be appropriate? Okay, so you typically want to use the form and sign it. You want to use this form for the state where you are a resident. That's the general rule. So for instance, if you are working here and you have an apartment in St. Louis, I would use the Missouri form. On the other hand, if you're working here in St. Louis, but you live across the river in Illinois, I would use the Illinois form. That's the same way we do it for our everyday estate planning clients too. Your state of residence dictates the type of documents that we would use for you. Now, if there's somebody here who's, maybe here on a very temporary basis or something, like they've been brought in as an emergency, that would be a situation where I would still use the state form from where you came from. Now, if you did sign a form in another state and you already have one, you don't have to sign a new one here. All states have a provision where they will respect a validly executed form that you signed in another state while you were a resident there. Rixie, do you want to chime in on that at all, or?
Yeah, that last point is important, and it also, I think, answers a question that popped up. The question was, even if my ID is from another state. It's not necessarily tied to your residency necessarily, and certainly not to the ID. These are contracts, and they're going to be basically independently respected contracts if they're valid wherever they are. Partly it's a federal principle that states give full faith and credit to other states' documents. But we do recommend that documents are Illinois-based documents if you're an Illinois resident, and the same is true for Missouri. Mostly out of practice, and institutions are more familiar with the documents they see more often, and they're more likely to accept them without objection, which is one of the big goals here. So it's not that a document will be rejected out of hand or not applied, but we do want to try to anticipate roadblocks and get them out of the way. So if you're an Illinois resident, all else being equal, use an Illinois form. If you're a Missouri resident, all else being equal, use a Missouri form. And I think that's probably the best guidance we can give.
The other thing is if you were sort of only temporarily here and going home or something like that, for the healthcare declaration and advanced directive forms, those are commonly available by most states. Like Missouri is not alone, having the Bar Association put that type of form up. Okay, do we have, you can either unmute yourself and ask a question if you want to, or you're welcome to put it in the chat too. Okay, I guess one more thing on the note on residence, on this ID from another state point, Your residence legally is where you are living and intend to remain for the foreseeable future. You know, you don't have to be committed to living in Missouri forever, but if you are living here, you have an abode here, this is where you consider yourself to be, that would be your residence. It is bolstered by other facts, like where you're filing your tax return and maybe where you're registered to vote, where you have your driver's license, but it's not like any one of those things would disqualify you from residence here. Okay, well, I'm not seeing any other questions in the chat, and so maybe we'll move on. You think, Rixie?
Yeah, but chime in, anybody, at any time if a question occurs to you.
Yeah.
Okay, so it turns out that everything that Adrian has been saying is one document with its multiple parts, but basically one integral document, which is one of several documents that make up most estate plans. And the phrase estate plan is not entirely synonymous with a will, but it's more or less synonymous with a will. But there's some other documents that are almost inevitably a part of a person's basic estate plan. And the common phrase is will. Do I need a will? I need a will. I hear I need a will. I'm not sure if I need one. And then will is the core of it. Some of you may have heard of a trust, a revocable trust, but we're not going to talk about that too much. We're really basically talking about a will. And another document that is sort of a sibling of what Adrian's been talking about. Adrian's document is a healthcare power of attorney. Well, it turns out there's another kind of power of attorney for financial purposes, and we can talk about that as well. So wills are crucial, and financial powers of attorney are important too, along with the healthcare powers of attorney that Adrian was talking about. So we want to discuss a little bit about what estate planning is and the role of a will for those of you who think that you might want this. It's important, I suppose, and it sounds lawyerly to say, but I guess I need to say it, that Adrian and I and anybody else on the BAMSL group, we are not going to be the lawyers for you. This conversation is much like a cocktail party where somebody corners us and says, hey, I got some questions about estate planning. And we say, oh, happy to answer any questions you want. But that doesn't make us the lawyer. And this is important because if you want to proceed with estate planning, what our real function here is to put you in touch with somebody who will be the lawyer, the real attorney-client relationship. And it's not that we don't want to do it, but it's that attorney-client relationships are real things, and they have legal ethics components to it, of confidentiality and conflicts of interest and privilege. And we can't just willy-nilly enter into even implied attorney-client relationships through all of this. So we have to tread these fine lines, but we're happy to do it for these purposes. But know that what we'll end up doing at the end of this, for those of you who want an estate plan, is we're going to, and you email us and let us know through that email address that's in the chat line there, that person will be your attorney. Of course, you'll have the opportunity to not pursue it. You're not forced into anything. But if it all works out, that person will be the attorney that you'll start the attorney-client relationship with. We're here to guide you through that document and to introduce you to basic estate planning concepts. Okay, so what is estate planning? It's two things. One, it helps you dispose of your assets. Dispose is not too fancy a word. It means, where do you want your stuff to go? And the second thing it does is it's a means for you to name the people that you want to do the disposing of your assets. And for a final little subcategory, an important one is the people who you want to be guardians of minor children. That's an important part of estate planning too. That appointment occurs in the will. So that's one of the crucial things a will does. It's not related to disposing of assets, but it should be out there front and center that is a crucial function of a will. So estate planning, you dispose of assets and name a guardian, and you name the individual fiduciaries who will facilitate that, who will actually do the disposing, the conservatorships, the custodianships, the guardianships, the attorneys, in fact, the various roles. So that's what estate planning basically is. What is a will? A will is a way to name a guardian. The natural guardian, if one of us were to pass away, I'll pick on me. If I were to pass away, my spouse would become the guardian of our minor children, just like my spouse is now. So no problem there. But the idea of naming a guardian is, what if your spouse is not available? What if your spouse also, for whatever reason, is not available and you need to name a successor? So it's important for that function. But it's also important for naming where your assets go. Not every asset you have is subject to a will. And this is an important distinction. What is subject to a will? Only the assets that you own in your own name. And I'm slowing down here because these are important phrases. Own name means not jointly with a spouse, right? In your own name, and not subject to some other form of ownership, like a beneficiary designation on a life insurance policy or a 401k, a retirement plan, and not subject to something like a TOD, transfer on death designation, which you often will see on an automobile and maybe even on a bank account. So if you own an asset and it's outright, it's yours, particularly if it's titled, and you say, okay, I own this thing. What happens if I die? The answer is, well, it'll be governed by your will. So it's not every asset. Full estate planning must take into consideration beneficiary designations, life insurance, real estate, all sorts of things that are beyond the scope of this meeting, and frankly will be maybe beyond the scope of the estate plan that you pursue here. But everybody on this call should know that is a part of estate planning, and we need to get it out there. Okay, Adrian, you want to jump in and add any commentary so far?
Yeah, sure. So just to give you an idea of what that will look like. So if you email the email address to get matched up with an attorney, and just so you know, so we have a lot of attorneys, estate planners in St. Louis who have volunteered to help, and they are from big firms and small firms and everything in between. And I think they feel very strongly about helping you all. The process that they will mostly follow will be, they'll get your contact information and reach out. They will probably ask you to fill out some kind of questionnaire or provide some information to them. They're going to want legal names for you, your spouse or partner, your descendants. And if you can kind of type that stuff up in advance, if you have time, or even sketch it out, that will save some time there. They're going to ask you probably for some information about your assets. They might ask you to ballpark your total net worth. The reason for that is part of estate planning often also involves doing some estate tax planning. The estate tax really doesn't apply to the vast majority of us anymore because the exemptions are so high, but they probably will ask a question just so that they know if it's even in the ballpark. I guess I should say this, if you end up getting matched with an attorney and you want to go through the process with them, they will do the healthcare declaration and durable power of attorney for healthcare for you as well. That's a form that I do for all my clients. And I would anticipate what they're going to do, and what we've asked them to provide for you is the healthcare declaration and power of attorney for healthcare, a durable power of attorney for financial purposes, which gives your agent powers to act with regard to your property during your lifetime, and then a will. And like Rixie said, the two main things that a will does is dispose of your assets after your death. It says who gets what. But then if you have minor children right now, that's the document where you designate who you would want to care for those children if something happens to both of their parents. And so, and then he mentioned the non-probate transfers. So I think we're good there. I was going to move Rixie into, now what do you do if you can't do any of these documents? Like what happens if there's just no time to get any of this done? Unless you had anything first, Rixie?
Yeah, no, that's important. But real quickly, since I referenced the financial durable power of attorney, just a couple of sentences about that so it doesn't seem so mysterious. It's a durable power of attorney, just like the medical one, except that it will authorize the person you pick, which is sometimes called an attorney in fact, sometimes called an agent. Those words are synonymous. to make decisions on your behalf, not about healthcare, but about financial issues or property, if you wish. The real question, almost the only question that you'll have to decide, other than who you want to pick, and then the success, but you'll want another person too, is whether you want it to go into effect immediately or whether you want it to go into effect only if you yourself are incapacitated. And there are reasons for doing one or the other. But if you're now sitting there thinking, yeah, I think I want to pursue some basic estate planning, I wonder what are the sort of questions I need to ask myself. Well, that's going to be one of them. Do you want a financial durable power to be effective now and now? So you're actually entrusting somebody to act on your behalf, even though you're perfectly able to do it yourself? Or do you say, no, there's no one in my life I trust enough for that. I just want somebody to step in if I'm in a comatose situation or an end of life situation where I'm alive, but I'm not functioning. Then and only then do I want somebody to step in. So arguments on both sides, but be thinking about that particular decision in addition to who you want it to be. On the will, another word about the picking the people. Adrian, her discussion of the healthcare, well, it's implied it's crucial to pick the right person. It's also crucial to pick the right person on the financial durable power of attorney. There is a fiduciary role in a will. Everyone's heard the term executor. Then for a while it was gendered with executrix, and then people did away with all that entirely, and now it's called personal representative. But that's the person, the fiduciary, who executes a will. In all of these cases, and guardian of minor children, picking the right fiduciary is crucial to having your documents be executed in a way that you want. For the healthcare one, pick somebody who you really deeply trust, who will do what you want for your end of life care or your medical decisions. For the financial one, pick somebody who will act in your best interests above all else, who knows your wishes and knows what you would do if you were able to speak for yourself. The importance of picking the right guardian is self-explanatory. And for an executor of the will or the personal representative, often it's the same person as the financial agent that you pick. May or may not be the same person as the healthcare agent you pick. Healthcare decisions and financial decisions are different skill sets, and they may not be the same person. But choose wisely. Do not take these decisions lightly, please. So give them some thought. Okay, Adrian, back to you.
Yeah, sure. And then I guess the other thing I would say is keep in mind, it's good to brainstorm those things in advance before you talk to an attorney. But if you and or your partner are kind of running into a brick wall on who you want to pick as guardians for children, that's the one that sometimes people get hung up on. That is a conversation that I guide clients through, all the time. And so the attorney that you get matched up with will be able to help you kind of work through that decision analysis and come up with the best person. Sometimes my clients ask me, well, what if the person lives out of state? That's something you could consider. What if, they have a really different philosophy than me, whatever. But good estate planning attorneys can guide you through that decision making to help you get to an answer so you can put a name in the blank. So we're at 8:18, so I'm going to kind of blitz through something really quickly here, just to kind of give you an idea of what happens if you don't sign any of this stuff, okay? Like it just gets way too busy or you can't get the notary or whatever. So both Illinois and Missouri will provide default law under both states that say who is appointed as the person in charge of your property, et cetera, if you can't do it for yourself or after your death. And the law will also dictate where your property will pass after your death if you don't have any kind of will or other designation. And it will also give a priority for who could be appointed by the court as a guardian for minor children. So those things don't just not happen. It's just that the statutes will dictate, more about that process. Let's talk about how your property passes first. So in both states, if you're married and you don't have any descendants, all of your property is going to pass to your spouse. And this is with regard, I'm sorry, my dog is barking. I hope you can't hear that. All of your property will pass to your spouse if you don't have descendants.
Well, all of the property that would be otherwise governed by a will
Right. So that's what I'm talking about. We're not talking about non-probate transfers.
That subset of all of your assets, the ones that are not jointly titled, not subject to a beneficiary designation, not subject to a TOD. The stuff that is outright in your name only is what would be subject to a will, or in the absence of a will, would follow the laws that Adrian is laying out.
Right. And so then if you are married and you have descendants, it's a little bit different in Illinois and Missouri, but in a nutshell, basically half of your property would go to your spouse, half of your property would go to your descendants. And again, it's that same property that's just in your individual name. It's not in joint name. You don't have a beneficiary designation on it, et cetera. So one idea there too is if like right now you're kind of looking at your property and you're thinking, okay, I don't have a house, I have a bank account, a life insurance policy, and a car. You might be able to obtain forms online from your financial institution, et cetera, to name a TOD or POD beneficiary, et cetera, if you want to make a different designation in there. Skipping ahead, if you are not married and you have descendants, your property will pass to your descendants. If you are not married and you don't have any descendants, no children, no grandchildren, nothing, then your property will pass in equal shares to your parents and your brothers and sisters who survive you. If any of your brothers and sisters don't survive you, their share will then pass to their descendants. It's a process called per stirpes. It means by the root, and it just means that, you know, one person's share then gets divided up amongst their descendants. So the law kind of creates an estate plan for you. It doesn't just all, you know, kind of stick around or whatever. That's how the property passes. As to the administrator, this is the role like the personal representative who would be in charge of marshaling assets, paying bills, making sure the property gets distributed, working with the court on making sure all those things happen. The statutes provide a priority of who's eligible to apply to have that role. A spouse always has first priority to apply for that role. If not, the court will pick someone that it looks like it's the best interest of the estate. That's almost invariably a family member, a brother, a sister, an adult child. In Illinois, the adult children will have a preference for being named in that if the spouse can't do it. And then for the kids, so if you don't have a will and there's nothing designating a guardian for the children, keep in mind that first, if a natural parent is living, so you're divorced, but you have custody of the children, as long as the other parent hasn't relinquished their parental rights or had their parental rights revoked, that parent would then get, you know, have custody of the children. But if both parents are gone, then the court will appoint someone. If your child is over age 14, they actually get a voice in selecting who the person would be. The court will ask them their opinion. It's not necessarily the deciding factor, but it's a factor they take into account. If none of those produce a person, the court will typically appoint a close relative, and there will be a process by which they make sure that the person is appropriate. Even if you name someone in a will to be the guardian of a minor child, the court is still going to supervise that process of appointment. So then if something changed between the time you wrote them down and when the court actually appointed them in the role, they would look at those facts and circumstances. And so that was the end of my notes for, you know, what happens if I have none of these documents. It's something we could take care of, and hopefully that provides some comfort. At this point, I think we can take more questions if people have more questions, or if anybody else has anything to add.
Well, I'll just sort of connect those dots there. It turns out that not everybody may need a will. And this is a little bit sacrilegious, I think, for estate planners. But if you are a single person and you have no kids and all of the property in your own name, you're okay with it going to, under the laws of intestacy, which is what Adrian was describing, basically to your parents and your siblings. It's not the end of the world if you die without a will. I'm not really formally recommending it, and under normal circumstances, no estate planner would say, hey, you don't need a will. But part of our goal here is to reduce anxiety and panic about all of this. So if you have quirky circumstances, or if what Adrian was describing would not reflect your wishes, and maybe profoundly would not, but maybe in some small way would not, well then yeah, and that might be a lot of you, then yes, you do want to try to get a document in place. But if you don't have a will and you die, it's not the case that it goes to the state. It's a common misconception that the Missouri just gets all of your property. It does not, right? What happens is it'll be disposed of under Missouri law. That's true. And that may not be your wishes. That's true. But it's not that it goes into the state treasury immediately. Ultimately, actually, if you had no relatives at all out to something like the 12th level of consanguinity, then the state might actually get it. But that is very, very rare. Okay. Enough commentary on Adrian's intestacy summary, and I think she's right. It's time to open it up to questions.
And I'm not seeing any questions in the chat. I'll just make a couple of points, and please do feel free to ask questions. I mean, we want this to be useful to you, and this is actually a point I want to make. We want this to be useful to you. We want to answer your questions or help you chase down the information you're looking for. We do want to, please don't hesitate to email that email address if you would like to get connected with an attorney who can work directly on your case. What we have asked our volunteers to do is, if they work with a healthcare worker who is working on this COVID-19 crisis, is to provide them with a will, a durable power of attorney for financial purposes, and a healthcare declaration and advance directive, and to get them to you in PDF format with signing instructions in 3 days. And so I think the 3 days would be from when they have the information from you in order to sign those or create those documents for you. And so, don't hesitate to reach out if we can help you further. And then also, Rixie and I and other members of the bar are able to do more of these Zoom sessions if they're helpful. And in fact, if we could collect questions, or if there's topics that we could, spend more time on, please give us feedback on how we can be more of a service to you.
There is a question in the chat room, or chat, whatever that is. The question is, can you explain TODs and PODs a little bit more, please? I'll take the first crack and let Adrian add her commentary.
Backseat drive.
I'm sorry?
I just made a joke. It's okay.
TOD stands for transfer on death. POD stands for pay on death. They both are they're similar in the sense that they both will govern the disposition of whatever asset they are attached to. So if you have a car and your car title says John Smith, TOD, Susie Smith, and then John Smith dies, all Susie has to do is take the death certificate and that title down to the Department of Motor Vehicles, prove that the current owner has died, and say, look, here's the TOD to me, Susie Smith, and the Department of Motor Vehicles, hopefully quickly, will transfer that. A TOD and a POD, there are ways of transferring property ownership by operation of that TOD or POD. So they don't get those assets don't go through the probate process. They're not governed by wills because they're governed by TOD and POD. POD is more commonly used on a bank account. That's all. It's the P is because you're paying it, not transferring it. So you might have a checking account that says, John Smith checking account POD to Susie, and then Susie will walk into the bank and the assets will be paid over. So TOD, POD, there's a distinction. Don't get too hung up on the distinction. There are two ways of transferring property, not through a will. It's through the TOD.
You can actually transfer a car by TOD in Missouri also. So if you own your car in joint name with your spouse, your car will pass to them at your death. If you designate somebody as the TOD beneficiary on your car, then they'll get it without probate at your death also. It's actually on the form when you renew your license plates at the Department of Revenue. There's a space where you can fill in the name of the person you would want to get your car.
And commonly done, by the way. So if you say, I don't have any assets except a car, well, then you can go down and get your car title and go down the DM. This is ideal situations, I understand. And go down to the DMV and say, I want to retitle my car in my name, TOD, Susie. I know these are unusual times, but that's sort of how the theory would work. And you could go to your bank and say, I want to retitle my bank account, POD, Susie. And then you've taken care of both of those assets.
Well, I want to be respectful of everybody's time because I know you all have had a long day and it's 8:30 now. We're happy to, I can stay on longer. If anybody needs to drop out, you're welcome to drop out. But I know Rixie thanked everybody at the beginning of the session, and I just want to offer my sincere thank you too for everything that you all are doing, and pass on the thanks of the estate planning community in St. Louis. There is a strong interest in supporting you and helping you. So let us know how we can help further.